and I didn't know anything. And I was stunned that my words and my positions carried great weight. While working with PSS, I gained a deep appreciation of the need for highly competent and zealous representation of all parties, and of the duty of the judge to make sure that all parties were heard fairly and with an open mind. I understand that one of the greatest attributes a judge can bring to the bench is an open mind, a willingness to listen, and the ability to base decisions on credible evidence in the case before the court. At the end of the day, judicial decision-making is only as good as the raw material, the evidence, the legal arguments provided by the advocates. To get the raw material needed for accurate and sound fact-finding and decision-making, the courtroom must be a place where all are heard, where all are respected, and where parties are encouraged to do their best to bring all relevant evidence before the court. Over the years that I've worked in the juvenile court, the court and attorneys practicing before it have become much more sophisticated in the litigation of the cases that fall within the court's jurisdiction. Still, I know that we can do better. I know that we can always be more responsive to the need to protect the public, as well as the needs of the young people and the families that are brought before the court. If given the opportunity to serve the Commonwealth as a juvenile court judge, I will strive to make decisions with a child's sense of time in mind, while cognizant of the fact that the decisions that are made can have lifelong impact. I will strive to make the best decisions possible, fully informed by all of the evidence and the law, and to ensure that whatever the outcome, the child has a safe, loving, capable, and permanent family. I can make no promises to this council about how I will decide any particular case. But I can and I do promise that if given this opportunity to serve, I will do my utmost to nurture a courtroom environment that values advocacy and the thorough airing of the facts and the positions of the parties. I promise that I will never lose sight of the fact that real people who have real problems are before me, and in my courtroom, all parties will be treated with respect and will be heard without prejudice or bias. I promise to be open to persuasion and to decide cases based on the facts and the evidence developed in the court and not on preconceived notions or unsupported conjecture. I promise that the law will be applied even-handedly and fairly to the best of my ability. And I promise never to lose sight of the immense trust and responsibility reposed in the office of a judge of the juvenile court, or in my obligation to serve the citizens of this Commonwealth to the best of my ability. I hope that these modest promises are enough to convince you to give me this great opportunity to serve our Commonwealth. Thank you for your time. Are there questions that I may answer to help you in your decision making?
Thank you very much. Councilor Viola, any questions?
Thank you. Well, you certainly have some great witnesses, and they all seem to bring along the same theme. They all know you, obviously. And the best witness is your son sitting there with his sincere grin on his face, so proud to be sitting there watching you. I really appreciate Mr. Johnson. Seems 31 years and still have that passion. That is what good public service is all about. To see that you still have passion for your job is wonderful. And in Mr. McManus's commentary, one of the things that he mentioned was just all of your years of experience in understanding the resources that will come to bear that you'll have to have knowledge of as a justice. So many come to the bench and maybe unaware of as intimately of those kind of services that are out there. And so having that, I think, is going to be very valuable along with all of the rest of your background. And understanding the consequences. Ms. Braxton talked about that you understand the consequences when things, I think from all aspects of a case. One of the things that I read, you mentioned that you're not going to have preconceived notions or so forth. see, but maybe you can just address that.
Well, that was an advocacy brief. That was a brief written in my capacity as the attorney for a young man who was charged with murder. As an advocate, I have an obligation to bring all relevant arguments before the court, and of course not to make any argument that is frivolous. So as an advocate, I thought that was an argument based on the developing understanding of neuroscience and cognitive development, psychosocial development, the 2005 decision of the Supreme Court in Roper against Simmons that needed to be made and needed to be addressed by our courts. As a judge, I would have a different responsibility. I would have the responsibility as a neutral to review all the evidence and all of the facts that are developed, and to test the science that I put forward in my memorandum with opposing experts, and under the crucible of cross-examination and direct examination. I would have the responsibility to review the legal arguments on the other side of the argument that I made. My argument was not joined on the merits. It was rejected as premature on a procedural issue, so it has not been fully briefed. I think I made a good faith, non-frivolous, adversary argument. Whether as a judge, with the benefit of full briefing, with the benefit of experts on another side, and the benefit of the adversarial testing of all that evidence, I would come out of the same position. It is a much closer question. And as a judge, particularly a trial court judge, I do not make the law. I apply the law to the cases that are before me. The position that I was arguing for in that writing sample is not the law of the